I mean, it was pretty wild to read. It is really rare that Rule 11 sanctions, so just sanctions on a lawyer or a company, even get filed. Like the motion doesn't even usually get filed, let alone granted. So it's a very rare time that a judge issues sanctions. And then to do so with the language that was in that order, I mean, that's a huge loss for the SEC. I mean, it's an embarrassment.
This content is brought to you by BitGo, which is one of the top crypto custodians in the crypto industry. BitGo works with many big companies and brands, such as Pantera Capital, Bitstamp, and Bitcoin IRA. Nike also selected BitGo to power its wallets for its NFTs. And BitGo has many great services, such as hot wallets, custodial wallets, self-managed cold wallets, and NFT wallets. Many institutions trust BitGo with its top-level security and incredible services, such as being able to deploy your capital while it's in custody, which includes lending, borrowing, trading, staking, DeFi access, and more. If you'd like to learn more about BitGo, please visit bitgo.com, link in the description. Welcome to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is Amanda Tuminelli, who's the Chief Legal Officer at the DeFi Education Fund. Amanda, great to have you on.
Thanks for having me.
Amanda, lots to talk about as it relates to what's happening in the crypto industry with regulations, the law, the courts, and much more. But I'd love to get to know you a bit better. Tell us about yourself, your background, and professional background as well.
Sure. So I am the DeFi Education Fund's Chief Legal Officer, which means I am the General Counsel and also the head of our litigation strategy. I'm sure we'll get into that a little bit more later. But before this, I was in private practice for almost 10 years. I was representing individuals and companies in the blockchain and Web3 space. I came at that from a white-collar criminal defense and securities litigation background. So before representing those kinds of clients, I was representing TradFi clients. And I also had a clerkship and did some work on the side with regular criminal clients. So that's really where I come from. And I've been at DEF for about a year now.
Now, what was your first encounter with Bitcoin, and did that lead to you having an interest to come work in the industry?
No. So my first encounter with Bitcoin was at a bar in the East Village when some guy was hitting on my friend and bragging that he was retired because he had made all his money in Bitcoin. And this was a long time ago. So at first I didn't even really know what he was saying. And I kind of just was like, that's made up. That's not a real thing. But then I actually did get the chance to work with crypto and Bitcoin and digital assets generally. But that was much later. I cannot claim to be an OG in this space. So I started getting really deep into it in 2019. I had a criminal client accused of running a Bitcoin mining Ponzi scheme. And our first task was to get him out of jail on bail, which required us to really dig into the government's claims about his financial assets and what they thought he had versus what he didn't actually have access to. And, you know, when you get arrested, you don't have all your devices. So it's very hard to make that kind of application to the court. But those issues were very interesting to me. They presented really different creative questions in criminal law, which isn't actually usually that creative of a space. So that's how I first got into it at work.
Wow. And I've seen an influx of lawyers and legal teams into the crypto industry over the past, 4 to 5 years, because we've had these regulatory battles. It's funny, you know, you mentioned that story because things are popping up here and there, and more lawyers are entering the industry. It's fascinating.
Yes, it feels like every big law firm now has a digital assets group. And there are amazing lawyers in this space who have been in this space for a very long time and are the go-to people to call. So I enjoy sending work to people who I think have really deep roots in the space and really get it. And I think it's great that people are joining. And I actually think it's a great place for young lawyers to get involved because there's just a lot of room for growth here. There's a lot of room for, if you understand the tech, you can really build a business in this space. So I think it's great from that perspective. But I just laugh that every big firm now has a digital assets group listed on their website. And I just don't know all the lawyers that are now in the space anymore.
Yeah, and that's a sign of a growing industry and asset class, right? It's here to stay. And so let's talk about the DeFi Education Fund. Tell us about the fund and its mission.
Sure. So DEF is a nonprofit, nonpartisan advocacy group for DeFi. So we educate members of Congress and other lawmakers about decentralized finance. We file amicus briefs in key litigation that we think will benefit the DeFi ecosystem. And we educate developers. We try to reach out and work directly with the community. And we also respond to rulemaking by regulators and raise issues that are key to DeFi.
And maybe we could start with some of the recent lawsuits and things that you've done, such as the lawsuit against the SEC regarding airdrops, and that's the Beba collection, if I'm not mistaken.
Yeah, that's the Beba collection.
Yes.
But yeah, we filed last week, and we're very excited about it. It was something we really believed and feel very passionately about. So in that suit, Beba and the NDEF together bring one claim that's under the Administrative Procedures Act, which says that the SEC, the APA requires the SEC or any other regulator to put out new rules for public notice and comment. We argue that in this case, there clearly is a written rule that the SEC has that it is enforcing through all of its enforcement actions against the crypto space, but they have not written that down for public comment, and they've not even given notice of what that rule really is. We say that it's clear to us that the rule is this kind of presumption that if there's a digital asset involved, therefore the SEC has jurisdiction and they can deem it a security or an investment contract, whether that's a token or a securities transaction to them. And we say that they have this policy and it's just not written down anywhere, and they are purposefully avoiding writing it down so that they won't face public notice and comment. So that's one of the claims. And then Beba made its own token, the Beba token, and did a free airdrop of that token. So they are seeking a court order declaring that the Beba token itself is not an investment contract and that the free airdrop is not a securities transaction. So those are the two different claims.
Yeah, I find it ridiculous that the SEC, in different ways, is trying to say an airdrop is a security because there's no investment. Like if I get a free airdrop, what if it's NFT or tokens? How is that a security? What if I went to some baseball game and they gave me free baseball cards, and it's for, I don't know, a popular player, and the value goes up. I didn't invest in it, so it's just ridiculous what they're trying to do.
That's exactly the point. That's you hit the nail on the head. There's no investment of money by a recipient of a free airdrop. And even if those tokens get traded on a secondary market and purchased for value at that point, that money is not going back to the so-called issuer of the token. So it should not meet a Howey test for an investment contract. And that's our whole point. And as you said, it actually does have a wider effect than just even in digital assets. So many regular retail companies are releasing NFTs or other kind of like marketing related tokens for free. So it would even affect kind of like consumer retail that's using digital assets in their business.
I guess the one good thing that I'm seeing is that this overreach from the SEC and some other government agencies, we at least have a balance in court where we're going in, we're winning some of these cases, and even holding the SEC accountable in that way. So what are your thoughts on this lawsuit and the outcome and the process? And these are all rookie questions I'm asking because I have no idea. But if you could take us behind the curtain a bit there.
Yeah, so we filed last Monday, so this is just the beginning. So the complaint went in Monday. The SEC has to get served with the complaint, and then they have at least 60 days from when they say they've received the complaint to respond. We expect that they will move to dismiss the complaint because that is most likely the first thing that they will do. They could ask for more time to respond. But when they move to dismiss, we'll get a chance to see what some of their arguments might be. But we have examples in our complaint of previous airdrop complaints that they have brought. They have, those cases include Hydro, like the Hydro token, the case against Justin Sun, and Tomahawk coin. So in each of those cases, the SEC specifically alleged that free airdrops or an airdrop of tokens in exchange for some form of a marketing effort, like a like on social media or a share of token news on social media. The SEC has said that that constitutes investment of money, and we just don't agree with that. So we have this precedent that we're using to say that clearly the SEC would bring that kind of case again, and that's why Beba credibly fears enforcement. Beba has a valid reason to worry that they might be next. And that's why they need a court to get involved sooner.
On that note, I noticed that an exchange out of Texas, Legilex, they're working with another crypto advocacy group to also sue the SEC regarding secondary market sales and other things. Do you think this is the way forward, that we have to be proactive and start, taking it to the courts to get answers, because Congress has not acted and the SEC is just doing whatever they want?
Yes, very well said. I think that this is the way forward. I think, as you said, Congress is actively considering different forms of legislation. And, especially last summer, we saw a variety of different bills get proposed and even a few passed out of the committee in the House. But I don't feel optimistic that Congress will actually pass full legislation anytime soon. So while we wait for that to happen, I think that we should appeal and we can appeal to the courts. Certainly the enforcement actions filed by the SEC don't seem to be slowing down. So for as long as they will continue to regulate by enforcement, I think we should also be proactive in testing their theories with people who are willing to do that.
Yeah. And then I saw recently too with SOB 121, that custody rule that they have, some members of Congress are pushing back and looking to repeal that. So I think to your point, we got to go on the offensive, whether it's taking them to court or getting the attention of members of Congress to get some of these things repealed where they have overreach.
Fully agree. I've really been glad to see the House Financial Services Committee, especially, Chair McHenry has gotten really involved, has put brought the fire to the SEC, has challenged their conduct, because it really does feel like they are on a crusade to eradicate the industry. I mean, it sounds dramatic, but I really think that's what we're seeing. I think increased their enforcement capacity by something like 50%, hired all these extra people. They're asking for more money from Congress to ramp up enforcement efforts, which, how much more can they possibly ramp up than they already have been doing? And I think they show no signs of stopping. So it's nice to see members of Congress recognize that and call that to everyone's attention.
Tough question for you. You've seen other industries, and have you seen this type of actions, level of aggressiveness towards an industry as we're seeing with crypto? Maybe it was with marijuana, I don't know, or different industries, but this seems unique in a way, or amplified more aggression because it's the disruption of money and the banking system and so forth. And I don't know if you can answer it because it's a tough question because there's a lot of layers to it.
No, I share your gut feeling there. It feels unique to me. Certainly in my career, I have not seen this targeted of a crusade, I will say, against a particular industry. I'm sure there are other industries out there that would tell us that they feel like they have been unfairly targeted. But just coming from a TradFi perspective, I'm not seeing this level of, vitriol towards any traditional financial service or company. So it feels unique to me. It feels like a piling on of multiple regulators. It feels like there's a new rulemaking by a different regulator every week. And then various enforcement actions, or we just find out after the case with kind of like a cease and desist order, settlement kind of order. But it just feels very frequent and very targeted.
Now, last week we saw there was a ruling in the SEC versus Coinbase lawsuit. I would love to get your thoughts on that.
Yeah, so we obviously had really high hopes because Judge Fela wrote this beautiful opinion in Risley v. Uniswap, which was a private litigant civil action. And I think she really does get the tech, and especially at oral argument on the Coinbase motion, I thought she asked amazing questions that showed her understanding of the nuance of the technology at issue. She does a particularly good job of differentiating the user from the token creator from a platform that offers that token for trading. And she, I think, separates the tech stack well, which is why I was so disappointed with the ruling last week. I will say the bright spot, and it is a big and valid bright spot for DeFi, is the fact that she dismissed the allegation that Coinbase acts as a broker through Wallet. We were very pleased to see that, for her to recognize that Wallet is non-custodial, that it is all user-directed, that it is merely software that allows the user to complete the transactions that they want to complete. So that was definitely the high point in my mind of the ruling. And I was really disappointed with the rest of it. I think that she is interpreting Second Circuit law. So like the appellate court that has New York in the circuit, she's correctly interpreting law like in the way that she has laid it out. And I think there's a reason why the SEC keeps filing in the Southern District of New York, and it's because they know the law there is particularly favorable to their conception of it. But I will say, we are pre-discovery. She does not have the facts before her. She is only interpreting the facts that the SEC chose to include in their complaint, and then the facts that Coinbase was able to include in their answer. That's it. She has no additional evidence that she can use to decide this motion, and it's really a motion that simply says that the claims the SEC brought were plausible, meaning they were not laughable, right? They were colorable on their face. So I think putting it in the perspective of this being a very early motion, and almost never do cases get completely thrown out on a motion to dismiss or a motion for judgment on the pleadings. With that context, I still have hope that there's room for her to change. I think specifically in her staking decision, I think with additional facts there, I am hopeful that she will come to a different conclusion on Coinbase's staking program in particular, but that all remains to be seen. I think we're years away from a final resolution.
So, rookie question for you. The SEC approved Coinbase to go public, right? And they jumped through all the hoops. They dotted their T's, dotted their I's, crossed their T's. And the SEC was aware of Coinbase's business model, which tokens it listed and staking and all that. And then years later decides to sue them. How does that come into play? And is that something the judge is going to take a look at? Like, what are we doing here? You approve them knowing their business model, but now you're suing them for that same business model.
Yeah, I think that's an example of more facts that will come out, and that she will be allowed to take into account when they move into discovery and they can develop that record. So I think that's a good example of something that could change the way she's thinking about the case. Obviously, that was not something the SEC chose to bring into the case in their own complaint, right? So I don't think she's had occasion yet to consider how that might change the outcome. But I hear you, and it feels intuitively right that the SEC has essentially gone back on their word and their evaluation. And I know they have these arguments that when deciding whether a company can go public, they don't do like a full securities analysis of each token. Like, I know they're going to say all those things, but it really does feel like we're in a crazy world where they would approve a business to go forward, knowing that they are then later going to take the position that that business offers securities and is violating the law by doing so. Like, it's totally nonsensical. So I hope that that gets brought before her. I think Coinbase has an amazing legal team and they are doing everything they can and they're doing it well. So I hope that that gets injected into the case at some point.
What are your thoughts on what impact the ruling in the Ripple case, where XRP was declared intrinsically not a security, secondary market sales were declared not a security? Now, that litigation is still going on with Ripple and the SEC, but more on the institutional side. But what impact, and because it was ruled by a judge in New York, and you mentioned like the Southern District and so forth, what impact that may have in it, this judge being able to look at all the different facts?
It is such an interesting example of a split within the same district court, right? Because as you said, Judge Torres decided the Ripple decision. She is a Southern District of New York judge. Judge Fela, a Southern District of New York judge, came out differently on secondary sales in particular. And then you also have Judge Rakoff, who issued the Terra decision, right? Was it? Yeah. Sorry. Okay. So you also have Judge Rakoff, who issued the Terra decision. All these judges are in the same district court. They are supposed to be bound by the same circuit law. That's the Second Circuit that sits above the Southern District. So it's interesting that you have judges coming to different conclusions based on the same law, different facts, of course. And I will say that Judge Torres was the opinion that we're thinking of is a summary judgment decision. So she had a factual record in front of her that she could analyze all the evidence put forth by Ripple when she made this decision, which is important. And Judge Fela was not deciding with the facts. So if it is the case that at the end of this whole thing, when Coinbase does get to summary judgment, and let's say Fela issues a decision that's kind of in line with what we saw last week, then you have a split. You have two judges really disagreeing, which makes it that much more ripe for appeal. It means the appellate court really should get involved and say what the law is in the Second Circuit. But you brought up the Legilex case. That is an example of a case in the Fifth Circuit. It's in Texas. So it's a different circuit, a different appellate court's law. So it could be a more favorable forum to make the arguments that Legilex is making. And then that court is not bound to use the same historical case law that the Second Circuit is using.
Interesting. So when you have this type of disparity between the judges and so forth, does that mean this has to go up to the Supreme Court at some point? Because historically, the Howey test and all that stuff was, I think, if I'm not mistaken, put forth by the Supreme Court. So the Howey test needs to be updated for digital assets, because they couldn't even fathom digital assets and blockchain networks back then, obviously. So does it have to go to the Supreme Court?
I think it probably is going to go to the Supreme Court. As we were just talking about, if the Fifth Circuit comes out a different way than the Second Circuit, that means there's a circuit split. And then the circuit split gets resolved by the Supreme Court. So I think the quickest way for it to go to the Supreme Court would be if these appeals happen in different parts of the country and come out to conflicting results. That means it's right for the Supreme Court to make a decision. Obviously, also people can direct appeal to the Supreme Court. So like if any of the Southern District defendants we're talking about lose, they can keep appealing to try to get to the Supreme Court. But the Supreme Court has discretion over which cases they take. Regardless, I think we're all in it for the long haul. I think the industry would welcome the Supreme Court getting involved and saying what the law is, because I really think everybody wants clarity. I don't think anybody is coming from a place of like, we just don't want to comply with any rules. There should be no rules. I mean, maybe some people are, but I think that the majority of us are really wanting clarity. And if that means getting it from the Supreme Court, all the better, because the SEC absolutely has to listen to the Supreme Court.
So dumb question. So let's say you have two things in parallel. The appeals go up to the Supreme Court, but Congress also has the FIT bill and all these things. Which one overrules which? Let's say Congress passes something at the same time there's a ruling from the Supreme Court. How does that work?
complicated question, but I'll do my best. So it depends on what issue the Supreme Court is deciding and whether the law that Congress passes directly contradicts or embraces that issue. So like if Congress did pass FIT, the Financial Innovation Technology Act, that is a market structure bill. So that could, depending on how it gets passed, resolve this question of are digital assets securities or commodities. So if Congress comes out and says all digital assets are commodities, but the Supreme Court takes the opposite view, the legislators' view is going to end up ruling supreme over the Supreme Court's view, unless FIT 21 gets passed and then the Supreme Court reviews that bill and says it's unconstitutional or violates some other principle. So generally, Congress is going to get to set the final answer here, but the Supreme Court could get there first, and then Congress could take into account how the case law has developed or vice versa.
Wow. It's fascinating.
Yeah, it could go a lot of different ways. It's we're really like speculating as to who's gonna get there first. It takes a long time to get to the Supreme Court, right? These cases would have to go up on appeal. That takes a couple years usually. So we're maybe Congress will act by the time it's right for Supreme Court review. Maybe.
Yeah, look, I mean, obviously we're closer on the congressional side, right? They got the couple of bills in the House, there's a couple in the Senate. And I know, like you were saying before, Patrick McHenry and these folks want to get those bills through. I hope they can get it out the House maybe next year in the Senate. And I don't know, they merge with Senator Cynthia Lummis and Gillibrand's bill. I don't know, but get something through.
Yeah.
We can figure this all out.
That would be good. I think that people are definitely trying. We have gotten the chance and the privilege to meet with members of the House Financial Services Committee, and there's definitely a desire there to figure this out and get something on the books. So it's just like, as you said, getting it to the wider Senate, getting it to the wider House, and getting both sides of the aisle to actually want to hear it and vote on it.
Now, speaking of what's a security and what's not, there were reports, and this hasn't been confirmed by the SEC, that the SEC is trying to classify Ethereum as a security. Some of this was validated by CFTC Chairman Ralston Benham in his testimony recently, saying he doesn't know what the SEC is doing with Prometheum and them custodying it as a security, Ethereum that is. What do you think about this? And is this kind of like a roadblock they're trying to put up to not approve that Ethereum ETF?
So I have no doubt that there is an investigation going on and the SEC has some internal view about Ethereum. They have been noticeably quiet about Ethereum over the past few years. So I think it was a little surprising that like now it's public that they are in fact doing this investigation. But I think there's a reason that they have been quiet about it, and they have only really come out. And I think Chair Gensler said that Bitcoin is a commodity, right? But he's never made a statement that Ethereum is a commodity. So I think that's pretty notable. It does not surprise me generally that they're doing all these investigations, because as we talked about, they seem to be casting a wide net across the industry right now. But it will be interesting to see, because in the CFTC case against KuCoin, they said Ethereum is a commodity. So there's clearly some debate and conflict between the SEC's view and the CFTC's view, which makes it all the more important that Congress get involved, because when you have two regulators who can't even agree on the same asset, it's clear that the law is not clear, and there needs to actually be some proactive guidance to the industry.
Yeah. And it seems like Gary wants to take the Ethereum ETF situation to court like they did with Bitcoin, the Bitcoin ETF. I think they're going to lose again, but I think they're trying to slow this thing down, roadblock it as much as possible, which is...
Yeah, it's a time game. They will, like you said, create roadblocks, create as much time as they possibly can before they actually need to take a position. I have no doubt.
Now, Kraken Exchange is also countersuing the SEC, and we saw 8 state attorney generals came out, and while they weren't fully supporting Kraken, they were criticizing the SEC, saying their approach is wrong. Is Kraken's lawsuit similar to Coinbase? Are they in the same boat?
I think there are definitely similarities there. I mean, they're both being accused of being unregistered exchanges and broker dealers and clearinghouses. So
Mm,
I think that they face similar claims. And the SEC certainly took consistent positions across both lawsuits, which is, something we talk about in our APA claim. They are basically saying that if there's a digital asset involved, this is a securities transaction. I think they're saying that in both cases. So there's definitely similarities there. I was also really pleased to see the amicus brief by the state attorney generals. I thought that was a really powerful showing by state lawmakers that a federal regulator is trying to preempt state law and in a way that is unlawful.
mm,
So I would guess that the judge is going to take note of an amicus brief filed by state attorney generals. It's not every day that you see an amicus like that.
mm. So dumb question here. Um, since we were talking about judges and different places and parts of the country and ruling in different ways, is the Kraken case anything related to the New York setup? If one let's say Coinbase rules, would that impact the Kraken suit and vice versa?
The SEC sued Kraken in the Northern District of California, so not in the same district where Terra, Coinbase, and Ripple is currently filed.
Mm,
So we have another opportunity here for a circuit split. So I think that it's possible that Kraken gets a different outcome because they are dealing with a different district court's interpretation of the law. That's the Ninth Circuit, so it's a different circuit, appellate court as well. And if they get, let's say, a ruling that's great for Kraken but conflicts with the Coinbase ruling, I imagine that there will be an appeal somewhere and it will go up to the appellate court, and then there could be another way that the law conflicts in two different parts of the country.
mm. So it goes back to that. It may have to go up to the Supreme Court.
Yeah.
Um, Question for you. With the losses the SEC has been taking, and some of them are very high profile, right? The big headlines on even like the Wall Street Journal and the Washington Times, whatever publication you have, like being called arbitrary and capricious. In the recent DebtBox case, the judge sanctioned the SEC lawyers. Maybe you could take us in the mind of some of these judges, based on your experience. Are they looking at headlines like that, and does that contribute to their verdict or whatever it may be, that hey, the SEC doesn't seem to be doing things right. They're acting in unlawful ways in many different ways related to crypto. Does that play a factor?
I think that DebtBox has to play a factor. I think that opinion was, I mean, it was pretty wild to read. It is really rare that Rule 11 sanctions, so just sanctions on a lawyer or a company, even get filed. Like the motion doesn't even usually get filed, let alone granted. So it's a very rare time that a judge issues sanctions. And then to do so with the language that was in that order, I mean, that's a huge loss for the SEC. I mean, it's an embarrassment. I think the words bad faith appear in that order like 40 something times.
Wow.
They said that judge said that there was pervasive misconduct within the SEC. I think he said gross negligence. And I think he made the point that the misconduct was not limited to just like the line attorneys in front of him, and it was reflective of the commission overall. I mean, that's a huge statement to see against a federal regulator.
Wow.
So I don't know how another court would not at least raise their eyebrows at that kind of language. We certainly cited it in our complaint,
Mm,
and we will definitely marshal those facts because I think it is an example of how the SEC's overzealousness to pursue this industry gets in the way of objectivity. I mean, they are supposed to be presenting the truth to the court.
right.
And I think their desire to win outweighed their duty to be objective to the court in that case. So it
Mm.
certainly should matter.
Let's talk a bit about DeFi as a whole. Um, Certainly DeFi is on the rise. We see that across the globe, people are using more DeFi applications and much more. But here in the United States, because we're still waiting on regulations, there are people who are looking to pseudo ban or kill DeFi. What are you seeing on that front? And it seems to be coming from different agencies, Treasury, obviously Elizabeth Warren is involved, and different people. What are you guys seeing, and how are you positioning yourselves to battle that in this year?
Yeah, I would like to say that I think it comes from a lack of understanding of what decentralized finance actually is and its benefits, because so many of the problems that everyone can agree exist in traditional finance are solved by decentralized finance. Bernie Madoff doesn't happen in a decentralized financial system. So I would like to think that members of Congress and lawmakers just don't understand DeFi, and like what they don't understand scares them, but it really feels more targeted than that. It feels that some do understand it and they just don't like it. And maybe that's because they can't control it, or they can't tax it the way they want to, or whatever it is. But what we're doing is trying to educate people. We are trying to, we do demos to members of Congress and show them what it looks like to use DeFi. Like, some people have never even have no wallet and have never even made a transaction on the blockchain. So we're trying to educate people about that. I think one of the biggest ways we are seeing regulators target DeFi, and it's not even like direct, it's kind of like in a roundabout way, is with mandatory reporting obligations. So we saw like the IRS do a broker rulemaking, redefining broker. We've seen the SEC do the one of the few rulemakings they did was on redefining what an exchange is, and what these different rules would do, if finalized, is impose a reporting obligation. But on who? Like, who in the DeFi tech stack is going to be able to comply with a reporting obligation? So the danger here is imposing an obligation which has a criminal penalty with like 60/50 for example. If you don't comply, you're facing a crime. But who in a DeFi ecosystem? No one, the whole point is not to collect user information and centralize it and create a honeypot, right, for somebody to eventually get access to. So it does feel like the way regulators are thinking about DeFi is just totally inconsistent with how DeFi is supposed to work. But I think our efforts are to make more time here, right, to let the technology advance, to solve the issues that regulators point to, because I do think there are technological solutions to a lot of the concerns that regulators have. But we need time to implement them. We need time for people to innovate and solve these problems.
Yeah, absolutely. And I appreciate the work you guys are doing. I know it's a tough battle, and a lot of people, like you said, are not educated about especially in government, about this technology, and they often have a knee-jerk reaction. Um, since we're almost up on time, I got some wrap-up questions here for you.
Okay,
First
sounds
is,
good.
if you could create your own metaverse, what would the theme be?
See, this is where I'm going to sound like a huge nerd, but I'm just going to go with it. So I'm super into fantasy fiction. Brandon Sanderson's my favorite author, if that means anything. But so I would love my metaverse to be some crossover between like Hogwarts and the world created by Brandon Sanderson.
Awesome. And rapid fire questions. Favorite food?
Uh, Sunday sauce, like my grandma makes.
Favorite musician or band?
Ooh, Lifetime, Billy Joel. Right now, Maggie Rogers.
Nice. Favorite movie?
Good Will Hunting.
Favorite book?
Bonfire of the Vanities.
What are you doing for fun as a hobby or pastime?
Other than reading fantasy fiction, I spend a lot of time with my dog walking around the city, and I do a lot of puzzles and other nerdy things like video games and that kind of thing.
Amanda, I absolutely appreciate your insights and knowledge. Thank you so much for joining me. And I definitely have to have you back on as things heat up in the courts and much more with the SEC.
I would love that. Thank you for having me.